Good afternoon, Your Honor. My name is Tom Salmons, and I'm a certified fire investigative technician with the International Association of Arson Investigators. I stand before the court today to articulate and explain how evidence from a recent fire was obtained legally. The fire department received a report of a fire at 614 Mays Street. They dispatched a first alarm assignment. Initial scene size up found dense black smoke emitting from the eaves and roof vents of the house. First Due Engine Company discovered a fire involved in an area around the TV in the living room. During cleanup, dispatch issued a full alarm assignment to a structure fire with children trapped 3 blocks away. Crews quickly finished loading the hose and responded to the fire, leaving the scene unsecured. Upon my arrival, family was also gone, so I made entry into the structure to begin my investigation. I began photographing the structure from the exterior to the interior. NFPA 921 is the guide utilized for conducting fire investigations. This guide indicates to start from the unburned to the burned during scene evaluations. While examining some of the evidence, I noted that personal items appeared to be missing, and the house appeared to be staged with old furniture and a broken TV. Upon further investigation, I noted some type of device melted behind the TV. As I collected the melted device, I saw what appeared to be a pour pattern behind the TV toward the kitchen. I collected samples from the pour pattern, and I notified law enforcement that I intended to charge the homeowner with arson. At this time, homeowners returned to the scene with their attorney. Case law has been established regarding fire investigations, evidence, and warrants. Since the engine company had left just prior to my arrival, it is precluded that the investigators continuing the investigation. Schultz versus State establishes a fire investigation is conducted in a reasonable amount of time. Fire department was on scene, gained access based on exigent circumstances. So initially, a fire investigator is not required to obtain a search warrant due to the purpose of the investigation. Purpose of the investigation is to determine the origin and cause of the fire. There exists no intent to obtain evidence that is criminal in nature when conducting an origin and cause investigation. Public duty doctrine focuses on the overall well-being of the community. Conducting an origin and cause investigation to determine how a fire started is an effort to prevent future fires. Additionally, lawful capacity of office enables firefighters to be on the premises. Michigan versus Tyler and Michigan versus Clifford are 2 court cases that have drastically influenced requirements associated with obtaining evidence in relation to the requirement of a warrant. Michigan versus Tyler established that once the fire department has entered lawfully, which in this case, exigent circumstances establish lawful entry, it's acceptable for firefighters to remove and secure evidence found in plain view. Obtaining evidence is further established under the plain view doctrine, which applies to government officials. The court did not differentiate between law enforcement and firefighters, and therefore any government official that observes evidence in plain view, the evidence may be lawfully obtained. Michigan versus Clifford established that a continuation of a fire investigation does not require a warrant. Additionally, Michigan versus Clifford expanded on homeowners' reasonable expectation of privacy by having the structure boarded up. When I arrived on scene, the house was found unsecured. Based on the information and case law presented today, I hereby request the evidence to not be suppressed, but admitted to the court. Your Honor, thank you for your time and consideration in this matter.